MBA program. The subject is MMPC 13 Business Law. I'm Ajit Runotra, and we are discussing about the business law MMPC 13. And this particular subject is divided into three blocks and respectively subsequently units. Block 1, Overview of Business Law. Unit 1, Introduction of Business Law. Unit 2, Concept and Principle. Under Block 2, Business Forms and Legislation. Unit 3 is the Partnership Act and the Companies Act. Under Block 3, Business Contract is a general principle for the Contract Act and International Contract for States. Under Block 4, Legal and Regulatory Framework for the Financing and the Investments of the Business. Banking, other allied regulation, foreign exchange management and related regulations, insolvency and bankruptcy law. Under Block 5, intellectual properties and data management is there, where we have to discuss and try to understand intellectual property right, data protection, and the privacy. And at the end, the Block 6 is related with business and sustainability. Under this, we have three units, Unit 12, 13, and 14, respectively, environmental protection and sustainability, competition law, and the consumer protection law. So, in this session, today we are going to discuss and try to understand and understood the basic concept of the course introduction under the Block 1. The course introduction, the occupation of the business plays a very extremely important role in the economy of any particular country or any economies. The law has become an important part of any business activity. A certain framework of law is necessary for maximum incentive to entrepreneurs, investors, customers. Business law has taken an important place because it secured the element of trust and certainty that are the vital and the economic transaction among the strangers. The scope of business law is very vast. It's take into the ambit the law related to all the activities providing indispensable for the successful conduct of the business or the business activity. The scope of business law is not restricted to the law related to the companies, but it is also provide law for the business activity conducted by other form of business organization. It may be a individual, small sector business, and a particular shop or service or trading in the form of partnership form or the companies or rather in the form of trust itself. So there are laws to deal with contract, the property, agencies, negotiable instrument, sale of goods, bail payment, guarantees, and intellectual properties, etc., etc. In relation to companies, there is a multitude of laws, such as corporate laws, securities laws, competition laws, foreign exchange laws, tax laws, and tax laws further divided into direct taxes and the indirect taxes. Therefore, understanding the basics of the business law are extremely very important for the students of business management stream to get a firm grasp on the concept and gaining deeper knowledge of a particular subject. Keeping this in view, the present course MMPC 13 on business law has been written and explained accordingly. All important legislations, laws, and related concepts and the rules and regulations have been explained to the students for their easy understanding of the particular subject. This course has been prepared with the following course outline to cover almost all the important laws and rules and regulation comes under the business law. So here we start with the block 1, that is a overview of business law. Unit 1 is introduction of business law. Second unit is concept and the principle. Unit 1, introduction to the business law. Basic objective after studying this unit, each and every student should be able to understand, explain the concept of the business understanding and their objectives, scopes, business law in the present business environment, and describe the various sources through which business law has evolved a structure. So first of all, it is an introduction, meaning of business, business environment, significance of business law, objective of business law, scope of business law, corporate restructuring under business law, source of business law, and respective subjects. First of all, we start with the introduction of the business law. The occupation of the business plays an extremely important role in the economy of any particular country. The act of engaging in business, which consequently result in the creation of job opportunities, trading, business, or providing the services, along with the generation of revenue for the economic sector, form a significant part in the national printing. For strong and productive economic, we need to have an adequate enforced system or the equally applied law, which has been increasingly control the entire business community for the investors, for the government, to the customers, for each and every one. A particular law will protect them, a particular their rights. Next is law has become an important part of any business activity. A certain framework of law is necessary for maximum incentive to the entrepreneur, investors, or the customers also. Business law has taken an important place because it secured the element of trust and certainty that are vital to economic transaction amongst the strangers. Because trust and certainty is the two vital part. When two parties or the entrepreneur or the customer will meet and interact with each other, uh, fair deal and the trust are the main important thing which a particular business law has taken care of. It also includes a study of legal compliances related to any business activity. In this unit, there will be a discussion on the concept of business and the objective of business law. The unit will help in the understanding of the significance of the business law in the present business environment and elaborate on the various sources of business law. Business law is a generic and umbrella term which provides legal and regulatory framework for doing a business activity. Understanding the basic of business law are extremely important for the student of the business management stream to get a firm control on each and every concept and gaining deeper knowledge of a particular subject. Three concepts establish a necessary framework for the most effective functioning of market in the modern nation. First of all, law, the rule of law and the property. Law has been defined in many ways. It has not easy to give a precise definition for the law. It has been defined as a rule of human action. A simple definition of law provides that the law is a formal social force, is made up of rules which are laid down by the state or the government are backed by the government enforcement. Rule of law. Under the rule of law, laws are made generally and equally applicable. They apply to all the members of the society and the various groups in the same way. Without the rule of law, major economic institutions such as corporations, banks, trade unions would not be able to function in a proper manner. And the government, many involvements in the economic sector, regulatory mechanism, tax system, customs structure, monetary policies, and like would be unfair, insufficient, and corrupt. Property, that the term of property has two meanings. Something that is owned and the ownership. It is the through the law of property that individual and the business organization can possess, use and transfer their respective private resources. The property is a legal fence that keeps other out without your permission and the consent. The right of property provides a basic for the private market and the modern business activities. Meaning of business. A business can be defined as an enterprise or the organization involved in the industrial, mercantile, and commercial activities. A business entity may be bought for the profit purpose to generate revenue or earn profit, or it can serve non-profit purpose supporting a charitable, uh, a social cause. A business may also be referred to the activities of the individual or the group of individuals engaged in the sale of goods, provision of services, and the profit motive. The term business may be understood as an organized effort of enterprises to supply customer with goods and services and to earn profit in the entire process. Business is a broad term and includes such various activities as production, promotion, wholesaling, trading, retailing, distribution, transportation, warehousing, finance, insurance, consultancy, and like that. Dixon has defined the business as a form of activity pursued primarily with the object of earning profit. Earning profit is the basic hardcore concept for any business activity. For the benefit of those who behalf of activities and conducting business vary in sizes as measured by the number of employees or the sales volume, etc. It may be a small shop or it may be a industry. The business law, also commonly known as commercial and the mercantile law, is that branch of law that conduct of relationship between the enterprise, companies, and the individual engaged in commercial matters. This section of law governs issue in relation to legal rights, duties, and liabilities, or the engage for the entire person who engage in the business transactions. All contracts, employment decisions, and the payment to the supplier are limited and protected by the business law. Each of the six functions area of the business are management, production, transportation, marketing, research and development, accounting and the finance, and the human resource management. Business law is a body of legal rules regulating business activities. Business law can also be defined as follows. Business law is that portion of the legal system which guarantees an ordinary conduct of business, fair and the settlement of any kind of dispute amongst the various parties. Business law established a set of rules uh, and prescribe conduct of that enable us to avoid misunderstanding and injury in our business relationship. Business and environment. The business environment consists of all those factors or forces which shape the conduct of business. Such factors may be categorized as internal and the external factors. Internal factors includes factors within the control of any business organization. External factors are, on the other hand, includes factors that are beyond the power of control of any business organization. Both internal as well as the external factor keep on changing and are dynamic in the nature. External factor are also includes laws, regulation, and policies that affect the conduct of business. Next is the significance of the business law. Business law is that a branch of legal system which promotes an ordinary treatment of business affair facilities and regulation of commercial activities in accordance with the established practice of law and provides for the settlement of disputes in an amicable way or manner. It constitutes that part of the legal system which is most fundamental to the national wealth creation. It also specifies the rule and the conduct that need to be adhered or for the creation of successful business relationship among the government, business entities, and the public, and the customer and the business enterprises. Objective of the business law: we enter into a contract each and every day. Establishing a contract is a very normal system in our life, day-to-day life. Some of these contracts are made consciously, for example, for the purchase or sale of any particular goods, purchase of shares of the company or the plot or piece of land. Entering into a contract determines the legal right of each and every party, giving rise to legal obligation as well. People who are engaged in the business activities, such as business owners, enter into a contract on a daily basis to further the business transaction. All business activities include a variety of transactions, which gives rise to contract on a daily basis. Some of these contracts are simple, as purchasing a goods from a particular shop, thus giving rise to the legal right and legal obligation. Business laws serve a variety of purposes, some of which are listed below. A comprehensive set of standards established universally. Business law are comprehensive and uniform set of standards that are applicable to all the business entities. Uniformity in law help in the maintaining a smooth relationship between the business and its various stakeholders, including consumers, suppliers, etc. It provides an environment where the business can be function smoothly and efficiently, as the same rule shall be applicable to all the business organizations falling in a particular category. However, there can be different compliances for the different kind of business organizations depending upon their size, nature of business activity, and certain threshold limits. It also helps in identifying and establishing the right and the liability of the various parties interacting with each other. Provides a framework for the reducing the harm caused to the either party due to fraudulent and unethical activities and the practice. Business law also provides for the steps that need to be followed while conducting due diligence before engaging with a particular company. Next is the promoting industrial growth. Business law not only provide a different provision for compliance for the business, but also facilitates industrial growth by protecting and promoting the right of the business. Lighting the procedure for the establishment of the business. The law dealing with the business group provide the necessary framework required for the commencement of the business corporation, along with the building of the strong foundation for the business entity to thrive in the market. The former process provides under the law also facilitates successful conduct throughout the 12 overview of business law life cycle of the business. For instance, Companies Act 2013 lay out the steps involved in the incorporation of the company and the provision related to the article and association and the memorandum association in detailed version. Enforcement of the rights. Business laws provide provisions for the judicially enforcing the right of all the parties involving in the business transaction and the activities. Thus, the business can approach the court to enforce the claim against the debtors or the right to the patent or the copyright or the right to hold the properties, etc. Contributes to the building of healthy business relationship. Law dealing with the business matter are extremely significant in the establishment of the secure and the effective business relationship amongst the concerned entities as a formation of strong business ties in an absolute must be building a strong economic country. Reduce possibilities of fraud. The robust and the effective business law framework helps in reducing the possibility of fraud as the parties entering into a contract or dealing with each other are well aware of their rights and respective liabilities, which would prevent them in falling prey to the illegal, fraudulent, and activities by other parties. Business law help maintain equality amongst the parties. Business law help in bringing about uniformity and maintaining equilibrium and the same platform and the equal protection to each and every party, as there are set rules which have to be followed by each entity. Different forms of business organization are regulated by the different law. Ethical conduct. Business law also help in improving the conduct of business, as the law have to be followed in letter in the spirit. Therefore, the business organizations have a responsibility of maintaining ethical conduct to run a business and business law while functioning in the society itself. Social responsibility. Business law also lay down the criteria for the business to function in a society. As the business utilize the resources of the society, there arises a responsibility of the business to give back to the society, give back to the various stakeholders. The this enables social justice and the social responsibility in the form of good employment practice, not discrimination, sustainable utilization of the resources, prevention of environment damages, etc. Lay down law in accordance with the involving standards. The business environment is ever changing and dynamic in nature. The law have to be enacted taking into account the economic and business environment of the country. Next is the providing penalties for the violation of the laws. Business law serve an extremely important portion of enlisting the various penalties that may be implied by the regulatory bodies to ensure that the conduct of the business activities conform to the prescribed standards set by the concerned branch of law. Insurance against risk. Every business involves inherent risk that may be related to the operations of the business, movement of or the transit of goods, and the financial risk, etc. Insurance laws provide a mechanism for ensuring against such unforeseen circumstances for business directors and the officers of the companies and can take the D&O insurance policies that protect us against future liability and any losses. Scope of business law. A better understanding of the business law and the scenario giving a rise to their emergence. It is imperative to understand the frame of social, therefore, which gave a birth to the branch of law. The scope of business law is very vast. It takes into ambit the law related to all the activities, providing indispensable for the successful conduct of business. There are laws to deal with the contracts, properties, agencies, negotiable instruments, sale of goods, bailment, guarantees, intellectual property, etc. There is multitude of laws such as corporate law, securities law, compensation law, foreign exchange law, and tax laws, etc. Corporate restructuring under business law. Corporate restructuring also form an essential part of the business development. Corporate restructuring is a process whereby a firm look to enhance its shareholders' value. There are numerous ways by which the company may look to restructure their business, like merger and amalgamation, merger through absorption, merger through consolidation, acquisition, takeover, demergers, joint ventures, and buyback of securities. These different form of restructuring are also supervised by different branch of business law, such as Companies Act, FEMA, Taxation Law, SEBI, Act, etc. Source of business law. There are many sources from which the business law evolved. Some of these main sources are Constitution. The text of the Constitution, along with its interpretation by the Supreme Court from time to time, is considered as the supreme law of the land or particular country. All laws and authorities falling from the traceable to the Constitution are recognized as the lawful power. The Indian Constitution established the fundamental principles and the rule by which the individual state are governed. Status. The status can be defined as the act of the legislature in the written form Legislative action called status are another important source of law. Another one is the cases. Case law play an important role in the shaping the law and the bringing out the relevance as per the prevailing conditions in the society. The interpretation offered by the judges in the judicial decisions in the form of precedents are one of the most important source of law. Customs. Custom is one of the most important source of law. It is possible to detect two basic elements in the makeup of the customs material facts, which is the actual behavior of states founded upon the performance of the state activities and the practice, which is believed by state that behave in a certain way that it was a legal obligation to act in a particular way. Treaties. Treaties are the source of international business law. They are the one of the source that have been mentioned under Article 38 of the Status of the International Court of Justice. Treaties are the obligatory in the nature and are founded upon the customary principle that agreement are binding upon the parties and must be performed in a good faith. Government policies. The legal power to make law comes to the government from the constitution. Laws are framed according to the policy of the government, the economic reform undertaken, provision of easy financing from MSME sector or the women entrepreneur, bringing new policy like e-commerce policy, etc. Uh, Now, in the second half of the our this class and the session, now we are coming to the unit two, which covers the concept and the principles. The concept and the principles covers the basic objectives. The objective of these units are understand importance concept under business law, appreciate various principles under business law, explain the status that fall under business law in India, discuss the methods for dispute resolution, including alternate dispute resolution (ADR), structure, introduction, concept under business law, principles of business law, status under business law, basic scheme of legislation resolution through courts, alternative dispute resolutions. First of all, we'll start with the introduction. Law has become an important part of any business activity. Business law has taken an important place in the legal study. Business law provides a legal and the regulatory framework for doing a business. It includes the study of legal compliances related to any business activity. This unit will elaborate the concept that fall under the business law. It will discuss the various principles of business law and status that falls under the business law in India. The unit also examines the dispute resolution mechanism for resolving business dispute, including the alternate dispute resolution mechanism. Concept under business law. Any business begins with the basic understanding that what has to be done under any particular business and in what form it has to be done. A business may be established for production, manufacturing, provision of services, sales, or purchase of the product. Every such objective involves a complex set of contracts, transactions, and mode of payments. Similarly, in the form of business has to be done, require deliberation about the type of business organization through which the business will conduct it. Whether the business involved in sales and the purchase activities. If yes, then basic concept relating to contract of sale should be well known and has to be established. Whether the business involved production or the manufacturing. If yes, basic concept relating to the contracts, intellectual property, product liabilities, contractual and the liability should be known. Whether the business involved formation of partnership If yes, then it is depending upon the type of partnership, the process of formation, and the forthcoming liabilities of all the partners should be very well known as per the business law. The partnership deed is advisable to be prepared, such as partnership have unlimited liabilities of the partners. Limited liability partnership (LLP) is a new concept. Provide opportunity to enjoy the benefit of partnership with the limited liability of partners through incorporation of LLPs. Next is whether the business involve incorporation of company. If yes, which type of company will be suitable for the business should be understood. When we talk about the companies, various type of companies are there, so that which type of company is suitable for the a particular business, this has to be discussed and clear. Whether the business is capital intensive, if yes, it should be known how the capital would be raised through public issues or the borrowing. Whether payments are required to be made, generally all business would be required payments to be made to different persons. Basic knowledge about the concept of negotiable instruments are required. Every business involves different type of risk. Concept relating to the insurance and the risk management should be known, and accordingly risk should be insured through the proper insurance policies. Disputes are also a part and parcel of doing any business. Concept relating to the right, remedies, dispute resolution, including alternative dispute resolution mechanism should be well understood. Legal and regulatory compliances should be properly adhered to by all the business. Principle of business law. Law and morality, the natural law school and the jurisprudence that the law is based on what is correct and what is right. The natural law philosopher on the moral theory of law, that is, law should be based on the morality and the ethics. Business ethics. Business, being a part of society, has a assortment of the responsibilities. Business have a relationship with other parts of the community, such as consumers, workers, vendors, market, or the government, or the banks. Business owe a responsibility towards these parties of the community. The degree of responsibility may vary from the business to business or stakeholder to stakeholder. Responsibilities are diverse natures such as safe working conditions for the employees, good quality products, profit maximization for the shareholders, and sustainable use of the society's resources. Ethics is the study and the practice of decision about what is right and good. Common law. Common law has been a major source of depending business law. Earlier, commercial law was not regulated through a specific status, rather the principle of the equity and the justice were adopted in the common law approaches. Next one is the natural law. The term natural law refers to the idea that there are certain ethical laws and the principles that are morally right and above the laws devices by the humans. The concept suggested that the individuals should have the freedom to disobey a law in enacting by the majority of people in their individual consensus goes against the law and they believe the law is wrong. Contractual principle. The contract as an agreement that creates and defines obligation between the parties. Section 2, subsection H of the Indian Contract Act 1872 defines the terms contract as an agreement enforceable by law. This also means that the contract is fundamentally an agreement having a power to legally bind the party involving enter into a contract. A contract is an agreement that is enforceable by a court of law or equity. Every contract involves at least two parties. The offer or is the party who makes offer to enter into a contract. The offeree is the party to whom the offer is made. In making an offer, the offer or the promise to do or refrain from doing a particular thing. The offeree then has the power to create a contract by accepting the offer's offer. A contract is created if the offer is accepted as it is. No contract is created if the offer is not accepted. The basic point is among the parties while establishing a contract. First of all, offer by one party, and the particular offer has been accepted by the second party. Once offer has been accepted by the second party, a contract or agreement has been created. Equity and the fairness. Equity and the fairness is the important principle of business law. The provision under business seeks to provide equitable treatment to all. There are law which vary according to the size of the business organization or the nature of the business activities, thereby differentiating between the business and the law applicable to them. Status under business law. There are various enactments brought forth by the legislature which provide guidance for the carrying out the business activities, along with their procedure, regulations, and enforcement. Some of the legislations are listed below. Indian Contract Act 1872. A contract is an agreement enforceable by law. The formation of contract plays an important role in business world, and the law of contract in India is governed by the Indian Contract Act 1872. This law has its origin in the English common law. The drafting and the formation of business contract plays an extremely important role in paving the way of business entities to establish business relationship. The Contract Act also encompasses provisions related to the law of agencies, bailment, guarantee, and indemnity. Next is Sale of Good Act 1930. The Sale of Good Act 1930 is an enactment to the defined and the amended law associated with the sale of goods, earlier falling within the review of Chapter 7 of the Indian Contract Act. It was initially a part of Indian Contract Act. The principle of the sale of goods come to the regulated under the separate act eventually. This act performed the function of protecting the right of buyers as well as seller, laying down the rules for transfer of ownership of particular goods, along with the creation of remedies for the effective enforcement. After that, Negotiable Instrument Act 1881, financial system encompasses credit as well as cash transactions. All transactions under the wing of finance are either dealt with cash payments or by issuing a negotiable instrument such as bills of exchange, checks, and hundies. To name a few, the Negotiable Instrument Act 1881 is an act to define and modify the law relating the promissory note, bill of exchange, checks. This assumed by the issuance of check as a mode of deferred payment are on. After that, Indian Partnership Act 1932. The Partnership Act governs the relations between persons engaged in the business who have decided to share the profit of the business undertaken by all or any one person on behalf of all. Partnership Act is also one amongst the bundle of laws playing an important role in regulating the business relationship. Uh, Limited Liability Partnership Act 2008. This is a new version of partnership as compared to the Indian Partnership Act 1932. Uh, LLP, Limited Liability Partnership. This act laid down a provision for the creation and the regulation of limited liability partnership (LLPs) and provides the flexibility and the dual benefit associated with the partnership as well as companies. LLP is the alternative cooperative body formed to conventional partnership firm where a partner's liabilities are confined to their respective investments in the business. Companies Act 2013. Though the legal system facility for formation of different business organization, a company or the corporation is the most preferred vehicle to perform industrial and the commercial activities. The Companies Act 2013 one enacted to consolidate and amend the law associated with the companies. The provisions of this Act shall be applicable to each and every company formed under the present or the previous Act, Companies Act 1956. Companies Act 1956 is the old version, and this has been replaced by the New Companies Act 2013. As per the formation and the type of the companies, there are normally four type of companies: private limited companies, public limited companies, one-person company, and Section 8 companies. Earlier, as per the Companies Act 1956, minimum two directors and the members are necessary to form a company. With this new act, Companies Act 2013, even one person can form a company. In our next session, we will discuss each type of companies in a proper manner. Next is employment and the labor law. Employment law comprises of law and rule that aid in the enforcement, regulation, and the governing employers-employees relationship. With a view to consolidate the different legislations dealing with the labor employment, industrial dispute, wages, and other employment concern matters. This branch of law, which was traditionally governed by contract uh, and numerous other legislation and the government in 2009. The government in 2019 brought four bills. They are the Code of Wages 2019, the Industrial Relation Code 2020, the Occupational Safety, Health and Working Conditions Code 2020, and the Code of Social Security 2020. Employment and the labor laws form an important part of the business practice being followed by the companies and enterprises and the contributes in maintaining a healthy relationship between employers and the employees. Tax laws. The financial obligation in form of taxes that is levied in income tax, capital gain, sales, and the property, etc. by the state government, central government, and also by the local authorities, such as the municipalities is involuntary in the nature, while direct taxes are levied on the taxable income earned by the individuals and the corporate entities. The burden to deposit tax is on the assessees themselves while filing their income tax returns and submitting their due tax as a self-assessment tax. On the other hand, indirect taxes such as goods and service tax, in short, we call them as a GST, goods and service tax, are levied on the sales and the provision of goods and the services, respectively, and the burden to collect and deposit taxes is on seller instead of the assessors directly. The Income Tax Act 1961 is the legislation dealing with the areas covered under direct taxes. Antitrust law. The Compensation Act, which came into force in 2002, is an economic legislation for the bringing about the economic development in our country. The primary aim of this piece of legislation is the avert practice having anti-competitive effects for the advancement of the competitions in the market. To safeguard the interest of the consumers and the guarantee freedom to trade to the market participants. This legislation is the successor of Monopolies and the Restrictive Trade Practice Act 1961. The Act laid out the provision relating to horizontal and vertical anti-competitive agreements having an adverse effect on competition, abuse domination, and combination of their regulations. After that, the next is a finance law. Finance laws are entrusted with the regulation of finance after taking into account the various risks that may be encountered among the financial spheres, such as banks, non-banking financial companies, NBFCs, insurance company, etc. The main function of the finance law is risk minimization, with the various risks being liquidity management, credit, exchange rate, legal, among others. This branch of law also deals with different kind of consensual security such as mortgage, contractual lien, charges, pledge, fixed charge along with the government and the process of consortium, the finance and the project finance. The Reserve Bank of India RBI play an extremely important role in the management and the regulations of the banks, whether it is a government banks or the private sector banks. Securities law and the regulations. Securities laws and regulation, also known as the capital market laws, and the regulation comprises the bunch of laws and rules that observe the issuance of securities. Securities laws and regulation advise the corporation on the step that need to be undertaken for offering their investment to the general public. They are extremely vital to the development of the market economy. The law associated with the securities may provide regulatory and transaction assistance, which assume significant role in the conduct of business in India. The Securities Contract Regulation Act 1956 governs the issuance of securities. The Securities and the Exchange Board of India Act (SEBI) is entrusted the function of regulating the securities market and safeguard the interest of the investors in securities. International business law. International business involves the sale and the purchase of goods across the border. It is the principal determinant for the aspect related to the international trade and globalization. The major benefit of uh, international business law transactions include increase in the level of profit, availability, availability of advanced technology and raw materials. To explore the avenues beyond the domestic market for the facilitating growth in the market, in market share, 30 overseas business laws are there. After that, foreign exchange laws, Consumer Protection Act, law of arbitration, intellectual property laws, and insolvencies laws. We will discuss each and every in our next sessions. Uh, After that, we also have a consumer code of act, and in our next classes, we will discuss each and every one in a proper manner. Thank you. Namaskar.